Q.49 What is an unwritten constitution? Give example of an unwritten constitution. Introduction. Understanding the nature of a constitution. A constitution is the fundamental law of a country that lays down the framework of government, defines the distribution of powers, and guarantees the rights and duties of citizens. It is the foundation upon which the political system rests. However, constitutions differ in their form and method of expression. On this basis, they are generally classified as written and unwritten. A written constitution is one where all fundamental principles and laws are systematically codified in a single document, like India or the US, whereas an unwritten constitution is one where constitutional principles are not contained in a single authoritative text, but are derived from customs, conventions, judicial decisions, and statutes. Meaning and explanation of an unwritten constitution. An unwritten constitution refers to a constitutional system not embodied in a single written document. Instead, it consists of a collection of customs, precedents, conventions, judicial rulings, and statutory laws that have evolved over time to regulate the organization and functioning of the government. This means that the rules governing the state are scattered across various sources, some written and others unwritten, and no single document can be identified as the Constitution in a formal sense. Thus, the term unwritten does not mean that nothing is written at all, but that there is no single codified text recognized as the ultimate constitutional authority. Definition. A.V. Dicey, a famous British constitutional expert, defined the unwritten constitution as: the Constitution is the sum of all the rules which directly or indirectly affect the distribution or the exercise of the sovereign power in the state. Hence, in an unwritten constitution, the Constitution evolves through practice and precedent, not through deliberate codification. Features of an unwritten constitution. 1. Not contained in a single document. Its provisions are spread over many sources, statutory laws, like Acts of Parliament, conventions, customs, and judicial interpretations. 2. Evolutionary in nature. It is the result of gradual historical development, not the product of a single constituent assembly or founding moment. It grows organically over time, adapting to political and social change. 3. Flexible character. Unwritten constitutions are generally more flexible than written ones, since constitutional changes can be made by simple legislation or convention rather than by a special amendment procedure. 4. Reliance on conventions and precedents. A significant part of the Constitution consists of political practices or conventions, unwritten rules followed out of respect and tradition, rather than law. Example: the British Prime Minister must be a member of the House of Commons, not a written law but a constitutional convention. 5. Supremacy of Parliament. In case of the UK, in an unwritten constitution, especially like Britain's, Parliament is sovereign. It can make or unmake any law, including constitutional laws. There is no higher written document to limit its authority. 6. Judicial and statutory sources. Judicial decisions interpreting laws and statutes passed by Parliament both contribute to the evolving constitutional framework. Example of an unwritten constitution: the United Kingdom, UK. The United Kingdom is the best example of a country with an unwritten constitution. It is often described as having an evolved or conventional constitution. The British Constitution is not contained in a single document but is derived from 5 major sources. I. Statute law. Acts of Parliament that have constitutional importance, such as the Magna Carta, 1215, the Bill of Rights, 1689, the Act of Settlement, 1701. The Parliament Acts, 1911 and 1949, the Human Rights Act, 1998. 2. Common law. Judicial decisions and customs that have developed over time form part of the Constitution. For example, the principle of rule of law evolved through court judgments, not legislation. 3. Conventions. Unwritten rules of political behavior developed through tradition and usage, such as the monarch acts on the advice of the Prime Minister. The Prime Minister must belong to the House of Commons. The government resigns if it loses a vote of confidence. 4. Works of authority. Scholarly writings of constitutional experts such as A.V. Dicey, Bagehot, and Erskine May are treated as authoritative interpretations of constitutional practice. Customs and traditions. Certain historical customs, like the opening of Parliament by the monarch, form part of the constitutional order. Practical working of the unwritten constitution. UK example, in the United Kingdom, the constitution is flexible and adaptable, allowing gradual reforms through ordinary parliamentary acts. For instance, the Reform Acts 1832, 1867, 1884, and the Parliament Acts changed the structure of representation and legislative powers without a formal constitutional amendment. This evolutionary nature ensures continuity, stability, and adaptability, though it also means there is no single fundamental law limiting parliamentary power. Advantages of an unwritten constitution. 1. Flexibility. It can easily adapt to social and political changes without the need for complex amendment procedures. 2. Practicality and simplicity. Changes can be made through parliamentary acts or conventions, making governance responsive. 3. Continuity and stability. Since it evolves over time, it reflects historical continuity and national traditions. 4. Growth with experience. Being evolutionary, it incorporates the wisdom of centuries, adapting to new circumstances gradually. Disadvantages of an unwritten constitution. 1. Lack of clarity. As there is no single document, ordinary citizens may find it difficult to know their constitutional rights and duties. 2. Absence of higher law. There is no supreme written authority to limit the legislature's power, especially in the UK. Parliament is legally sovereign. 3. Possibility of abuse. Flexibility may allow governments to manipulate conventions for political advantage. 4. Uncertainty in interpretation. Since conventions and customs are not legally binding, disputes about their scope can arise. 5. Lack of judicial review. Courts cannot strike down unconstitutional laws, as all parliamentary acts are legally valid. Comparison with a written constitution. India or USA. Unlike the unwritten British Constitution, the Indian Constitution, 1950, is a written, codified document, drafted by the Constituent Assembly and containing 395 articles and 12 schedules originally. It clearly defines the powers of different organs, rights of citizens, and procedures for amendment, making it both comprehensive and supreme. Thus, while Britain's constitution is flexible, conventional, and evolutionary, India's is codified, supreme, and partly rigid. Summary for quick understanding: an unwritten constitution is one where constitutional principles are not contained in a single written document but are drawn from customs, conventions, statutes, and judicial precedents. The United Kingdom is the classic example of such a system, where the constitution has evolved over centuries without formal codification. While unwritten constitutions are flexible and adaptable, they lack the clarity and legal certainty of written ones. Quick revision notes. Meaning: constitution not codified in one document. Source: customs, conventions, statutes, and precedents. Main example: the United Kingdom. Nature: evolutionary, flexible, and conventional. Advantages: adaptable, simple, continuous. Disadvantages: unclear, open to abuse, lacks higher law. Contrast: India and USA have written constitutions. One-line questions and answers for revision. 1. What is an unwritten constitution? A constitution not codified in a single document. 2. Is everything in an unwritten constitution truly unwritten? No, it includes written laws but lacks one authoritative text. 3. Which country is the best example of an unwritten constitution? The United Kingdom. 4. What are the main sources of the British Constitution? Statutes, common law, conventions, and judicial decisions. 5. Who defined the British Constitution as the sum of rules affecting the sovereign power? A.V. Dicey. 6. What is the nature of an unwritten constitution? Flexible and evolutionary. 7. What is a major advantage of such a constitution? It adapts easily to change. 8. What is a major disadvantage? Absence of a higher law to control parliamentary supremacy. 9. What is the constitutional status of Parliament in the UK? Parliament is sovereign. 10. Which type of constitution does India have? A written and partly rigid constitution. Final connection. An unwritten constitution, as exemplified by the British system, represents the organic growth of governance through history, custom, and practice rather than deliberate design. Its flexibility and continuity have ensured political stability for centuries, yet its lack of a single supreme text makes it dependent on tradition, convention, and political morality rather than legal rigidity. In contrast, modern democracies like India and the United States have preferred written constitutions to ensure clarity, uniformity, and judicial enforceability, reflecting the evolution of constitutional governance from custom to codification.